I've always believed, because I do both transactional and litigation, I've always believed that if you've done litigation, now all the transactional lawyers are going to argue with me, but if you've done litigation, a lot of litigation, particularly business litigation, that prepares you very well for a perspective on transactional work, because you are already dealing with what happens when either the contracts are drafted properly or not. They may be, the fact that you draft a great document doesn't assure that you're not going to be in litigation.
Right, absolutely. There are various times, and I see a lot of, issues and contracts that transactional attorneys don't often see because I've litigated these issues. I mean, when I see possible parole evidence is going to be a factor, maybe the liquidated damages provision is going to be a factor, maybe we should put more into the recital, maybe we should add, certain points here and there, because I've seen, these litigations regarding these provisions. It's definitely very helpful.
Parole evidence. Now, to the non-lawyers out there, they're not going to appreciate it, but when I am involved in true litigation, when you're really fighting in court, parole evidence is almost always an issue.
Yes.
And I'm always looking either to exclude evidence or to get it in, and it is so big in just the kind of standard incorporation clause.
Right.
Often is not very effective, and people don't understand that.
Yes, absolutely. I just talked about that in our panel where there was a recent California appellate court case called Rivers Land, and it definitely discussed parole evidence. It diluted, actually, the parole evidence rule. The court was able to, the court actually did allow parole evidence in to show a party's allegation of fraudulent intent in the contract, and even when that varied from the terms of the contract. And so that made a lot of attorneys nervous. I hear a lot of war stories, relating to parole evidence and the recent developments in terms of really diluting that provision, allowing a lot more testimony in to show the party's intent relating to the contract terms. And as attorneys, we really have to focus on maybe we should be looking at redrafting the contract so that the integration provision maybe shouldn't be at the end of the contract, maybe it should be bolded, maybe it should require additional initialing, maybe there should be additional recitals regarding the integration provision. We need to put in more prophylactic measures. Maybe there should be a more detailed cover letter. So, definitely it's going to create a lot of problems in the future.
This has been a production of CRE Radio, hosted by Howard Klein.